All right, so the rule of law. I hear mumbling. What is the rule of law? Anyone? It's one of these things that we talk about as being important in a democracy is the rule of law. It's important that there be freedom, that the people have rights that they can freely express. It's important, obviously, that that the people have the right to vote. It's important that the people feel as if they have some equal stake in the democracy. But the other thing, sort of the third leg of the tripod, we say, is the rule of law. The rule of law just simply means that when the society operates on the basis of laws rather than on the basis of what people want. Now, what people want and what the laws are might be the same, but where they are in disagreement is where it really counts. And in a society that operates according to the rule of law, the law wins. If you think back to the first class and talking about the idea of what a constitution is, and that it's a set of predetermined laws and traditions by which a society is governed, and why it exists. And it exists in part so that people know where the boundaries are drawn for the society, where the red lines are, what you can do and what you can't do. And that minimizes, or hopefully eliminates, the extent to which things can be done arbitrarily without any reference to which people can refer. Because when that happens, then there's likely to be abuse. When there's law, and particularly when everybody is subject to the law in the same way, when there's what we call equal protection, more on that next time, then a society can be deemed to be more fair than other societies, which is an important distinction as well. So, also going back a couple of weeks, we talked about how the first recorded democracy that sort of resembles the one that we have here was in ancient Athens. What we have in ancient Rome, at least until about 50 years BC, is the concept of a republic. And this also very heavily influenced the way that we ended up erecting our republic here. Rome is a republic for about 450 years. The word republic, by the way, comes from two words in Latin, res publica, which means the people's thing or the people's concern. So inherent in a republic is the idea that it is sort of inherently democratic. Power is exercised by the people. Where we distinguish it from a democracy is really more in the extent to which democracy is a voting kind of form, whereas a republic is a government kind of form. So the United Kingdom is a democracy also. They have free elections, and they're among the freest elections in the world. I would argue, in fact, at this point, that they're probably freer than the elections that we have here. But it is not a republic. It is a monarchy. It is an extremely limited monarchy, but it is a monarchy nevertheless. Saudi Arabia is a monarchy, and it is not a democracy. So you can have monarchy with democracy. You can have monarchy without democracy. You can have a republic with democracy, and you can have a republic without democracy. Except that there's some question to which a republic is really a republic if it does not afford the people true power. Most countries call themselves republics today. Essentially all of the countries that are not monarchies call themselves republics. But for many of these republics, we do not consider them to be free in any real sense of the word. North Korea calls itself a republic. China calls itself a republic. Many of the North African states are republics as well, but they're also functionally dictatorships. So it's important to be able to distinguish among those terms. Now, 322 BC, Alexander the Great dies in the city of Babylon, and his empire is carved up. And it's really sort of with the division of that power that Rome is able to emerge in its own right as a significant power. For about 100 years, Rome fights the city of Carthage, which is in what's current-day Tunisia in North Africa, in a series of wars in which Rome is ultimately powerful and establishes its rule from across the Mediterranean Sea, if you sort of get a visual. So here's Rome, here's Carthage, and so Rome is able to establish control of territory outside of the Italian peninsula and begins to build an empire essentially on that basis. He conquers Athens next. And in the last century BC, there emerges within Rome this figure, Julius Caesar. He comes from a wealthy family and sort of sets out in his young adulthood to make an even greater fortune than he was born into. And to do this, essentially, he raises an army. Remember, they don't have standing armies in the ancient world, so it's not as if there's soldiers that are looking to be drafted. And armies are private. And in most cases, the army is going to be run by the monarch for the particular place, or the ruling party, or the ruling person, if it's a dictatorship. But there are also private armies, and Caesar's army is one of these. His first major campaign, which is successful, is conquering Gaul, what's today France. But eventually he also conquers Spain, and he conquers into what's currently Belgium and the Netherlands as well. When he is sort of done waging these wars in Western Europe, he makes clear to Rome his intent to return to Rome, and the rulers in Rome tell him that he cannot return with his army. Caesar considers this and then says that, as he has famously said, the die is cast, and makes the move to cross the river back into Rome with his army. Anybody know what that river is called? It is a famously named river, although it is a rather small river. Anyone? It is the Rubicon. So when you hear people talking about crossing the Rubicon, they're referring to Caesar crossing back into Rome with his army, which he then used to conquer Rome, after which he was named dictator, so was able to rule by decree. This was the beginning of the end of the Republic in Rome. Although, because of his pretensions to dictatorial power, Caesar was ultimately assassinated in the Senate by other members of the Senate, and it returned to a republic for a short period of time. Now, when it operated as a republic, and this is here for illustration and not for study, this is the system of government under which the Roman Republic operated, and then continued to operate to a certain extent when it became an empire, which it was from a few years BC until 476 BC, or AD rather. So for about 500 years, Rome is an empire. It's at that point the largest empire in history. It controls all of the land in the Mediterranean basin. It also conquers all the way into what's currently the United Kingdom up to the border of Scotland. So it's a large empire. And the reason why they create a system of government that is as complicated as this is to satisfy the demands of several interest groups to having some say in the power structure for the republic. There are wealthy agricultural landowners who make up the economic elite, and they're going to continue to hold a significant amount of the power. There are also people with military backgrounds like Caesar, and they're going to have their own base of support within the government. But there will also be a place in the government for the common people to vote, and they will vote representatives into an electoral body. But the power of that electoral body will always be checked by other bodies. And the executive power, such as it exists, which is for the period of the Republic, basically put into the hands of two people called consuls. Their power will check each other, and their power will check the lawmaking bodies, and the lawmaking bodies will check the power of the consuls. It's a system that's very much designed to prevent anybody from really getting the upper hand, which is the reason why it ultimately is necessary for somebody like Caesar to use physical force to gain control over it, and to have a sterling reputation that people actually want him to take control there. They view him as a hero, and they view him therefore as a desirable leader. But before he arrives, this is the highly complex way that things are set up. Contemporary with Caesar is Marcus Tullius Cicero. And he is trained as a lawyer and then goes into politics. He's elected as one of the two consuls, one of the two executive power holders in ancient Rome. When Caesar is in Rome, before he goes out and conquers Western Europe, Caesar forms what's called a triumvirate, a group of three men who rule the city more or less. They leave sort of the functioning offices of government, but they really hold the power between the three of them. Cicero is offered a position within this triumvirate, which he refuses because he is very protective of the proper functioning of Rome's republic, and then sides against Caesar when Caesar returns to Rome with his army. He is glad that Caesar is murdered, because it is for him the only way for the republic to be maintained, which he sees as a sort of an inherent good. When there is a second triumvirate, which is formed, and probably the more famous of the two triumvirates, this is formed by Caesar's nephew, Octavius, Mark Antony, and I forget who the third one was, but he's less important. Octavius becomes the first emperor of Rome, Augustus Caesar. Mark Antony, you might know, is the consort of Cleopatra. When this second triumvirate emerges, from which ultimately the empire itself will emerge, just as he opposed the first triumvirate, Cicero opposes this triumvirate as well, and for that he is, like Caesar before him, he is assassinated. So the reading that we have from Cicero is on page 531. So please turn there. So because you all very assiduously do the readings at home and really sort of have them committed to memory before you come here every Tuesday and Thursday, you probably know, and I don't need to tell you therefore, that Cicero wrote very much in the style of Plato in the form of dialogues. Unlike Plato, what he did was include himself as a character in them. Plato did that occasionally, but only as a very minor character, never as in an actual speaking role, at least not in any of the famous dialogues. What Cicero does with the dialogue form from Plato, and Cicero is very strongly influenced by Plato in terms of his basic ideas about things like the nature of good and evil. Although not political affairs, because remember, Plato is very hostile to democracy as a form of government, whereas Cicero is quite fond of it. He owes to him, nevertheless, this form of writing in dialogue, except that he just sort of does this as a way of representing his own ideas rather than writing in straight prose. So, beginning on page 531, the topic of discussion is the civil law, the jus civile, as it is stated in the Latin on that page. Atticus, one of the two people with whom Cicero is speaking in this selection, puts the question to him, asks him to state his opinions on the civil law. And Cicero says, I believe that there have been most eminent men in our state whose customary function it was to interpret the law to the people and answer questions in regard to it, but that these men, though they have made great claims, have spent their time in unimportant details. What subject indeed is so vast as the law of the state, but what is so trivial as the task of those who give legal advice? It is, however, necessary for the people. But while I do consider that those who have applied themselves to this profession have lacked a conception of universal law, yet they have carried their studies of the civil law, as it is called, only far enough to accomplish their purpose of being useful to the people. So he begins by talking about the role that legal scholars in ancient Rome had. When he talks about lawyers, he's not talking about people that are giving, that are representing people in courts or anything like that. But he does make an important distinction here that's worth pointing out. And that is to say, it is between law with a capital L, as rendered in our translation, and law with a lowercase l. As, for instance, in the third line of that paragraph, he says that the customary function of these lawyers was to, quote, interpret the law to the people, lowercase l. But then a few lines below that, he says, I do not consider that those who have applied to this profession have lacked a conception of a universal law, with capital L, yet they have carried their studies of the civil law, lowercase as it is called, only far enough to accomplish their purpose of being useful to the people. So what's the distinction here? Why does our translation make this distinction between talking about one form of law and capitalizing it and another form of law and not capitalizing it? And part of this is that he puts the civil law with the lowercase l, and he puts the universal law with the uppercase. What's the difference? Yeah.
So kind of like universal, kind of like how like religion states, kind of like religious laws. That's like you don't really change them, you just believe them. All civil law, you change them with different laws and enactments.
That's a pretty good distinction. So what you said was that there's sort of our immutable laws, the unchanging laws, the universal laws, which we very much, and Cicero does as well, ties to religious belief. And the civil law with the lowercase, which are those laws that can be changed. And on some level, the way that this breaks down is to say that whereas universal law is objective, civil law is subjective. And so, now, it certainly is possible that the universal law and the civil law of the society in which you are living are in accord with one another. Right? I mean, and we operate mainly within a Christian cultural milieu. So to sort of put it in terms that are most broadly understood, if the basis of Judeo-Christian universal law are the Ten Commandments, then some of these are parts of civil law, right? You shall not murder, you shall not steal. But some of them aren't. You shall not commit adultery, you shall not covet your neighbor's property. Or you shall not bear false witness. Like that one actually, it depends, right? You can lie, but not under oath. So, that's the distinction. Does the civil law match the universal law? Now, what he also then distinguishes between these two types of law is to say that universal law comes from nature, and that civil law comes from human beings. And he expands on this if you turn to page 533. And the speaker, under that subheading that says law is the highest reason implanted in nature, says, well then, the most learned men have determined to begin with law, and it would seem that they are right if, according to their definition, law is the highest reason implanted in nature, which commands what ought to be done and forbids the opposite. This reason, when firmly fixed and fully developed in the human mind, is law. And so they believe that law is intelligence, whose natural function it is to command right conduct and forbid wrongdoing. So he says that when human beings operate at the highest level of reason, right, and your reason is your ability to apply evidence and logic to solve problems, basically, in the simplest possible way of putting it. When human beings operate with the greatest possible reason, their conceptions of right and wrong will match the objective considerations of what are right and wrong that never change. He continues, if this is correct, as I think to be in general, then the origin of justice is to be found in law. For law is a natural force. It is the mind and reason of the intelligent man, the standard by which justice and injustice are measured. But since our whole discussion has to do with the reasoning of the populace, it will sometimes be necessary to speak in the popular manner and give the name of law to that which is in written form decrees whatever it wishes, either by command or prohibition. So it says, okay, on one hand, there's this capital L law, that thing that exists in the mind of human beings when they are applying their greatest possible reason, and that yields justice. But he concedes immediately not everybody is highly intelligent and operating with a maximization of reason and logic. And so for these people, there is, it's easier and more informative to talk about this civil law, this lowercase law. And he says that for these people, the distinction is between what's written down, civil law, and what we sort of all know if we are at the highest level of reason, the natural law, the universal law. And again, it's ideal that the two be identical, or at least very close together. He continues, but in determining what justice is, let us begin with the supreme law, which had its origin ages before any written law existed or any state had been established. So a final wrinkle that he puts into it is that to identify justice, you can't look at the civil law. You can only look at the universal law. So think back to Plato talking about justice in Republic. Right, the big question that Plato wants to solve in Republic is this question of what is justice. And after he goes through the initial stage of saying to his friends, or in the case of Republic, one of the people is his enemy, asking them what justice is, and the guy says, well, justice is what the law says. And Socrates says, well, what if the people that are in power are bad people? Then is what they say the law is going to be actually be justice? And the guy gets angry at Socrates and storms off, calls him names and then storms off. But Socrates says, well, let's stick with the question for a minute. Maybe we can find what justice is by considering the highest functioning city, the rulers of that city, the things that they pursue in ruling, and identify justice that way, sort of indirectly. Cicero does something similar, but he doesn't appeal to philosopher kings like Plato does. He appeals to something similar, which is this highly reasonable person. Because after all, what you can't do is know what God or the gods say, right? That would be the ultimate source of law. And remember that ancient Rome is a polytheistic society, like the ancient Greeks. It's the same set of gods they believe in with different names. So they've got, a thunder god and a war god and a love god and all these other deities. And while you can rely to some extent on divination, right? You can go to an oracle and get the story about what the gods want or think from that person, or from some divinely inspired text, you're relying on your belief about a person being reasonable to accept their point of view about the law, or you are relying on faith. And faith, by the way, just to finish this point out, faith is a reason-suspending process. So, which isn't just to denigrate it, right? It's just that it's different from reason, right? We believe things in faith because without evidence. So it appeals to a different set of, a different way of thinking about things. What we believe on the basis of faith, we say doesn't require reason, because that's the very nature of faith. But if you are mingling the two here, as he most certainly is, then it raises some difficult questions to answer. And that's what I want to sort of consider as we continue to go through this. So again, just to repeat those last three lines, but in determining what justice is, let us begin with that supreme law which had its origin ages before any written law existed or any state had been established. So let's go back, he says, in time to some period before there was a written law. And we can figure it out then. And Quintius says, yeah, that would be great. Marcus says, yep, let's do it. And Cicero, who is M, by the way, Marcus, continues on page 534. Actually begins just before on 533. That animal which we call man, endowed with foresight and quick intelligence, complex, keen, possessing memory, full of reason and prudence, has been given a certain distinguished status by the supreme God who created him. For he is the only one among so many different kinds and varieties of living beings who has a share in reason and thought, while all the rest are deprived of it. This is the classical understanding of what distinguishes us from animals, right? We have reason, they don't. In a religious standpoint, this is equated with a soul. We have a soul, they don't, right? I hate to break it to you if you've got a dog or a cat that you love and believe in an afterlife. None of your mainstream religions teach that they have souls. Only you do. That's if you believe that. So, and that's what makes us different, right? We've got this reasoning ability within us. But what is more divine, I will not say in man only, but in all heaven and earth, than reason. And reason, when it is full grown and perfected, is rightly called wisdom. Therefore, since there is nothing better than reason, and since it exists both in man and God, the first common possession of man and God is reason. We have reason. That's what distinguishes us from the animals. God gave us that. That's the thing we share in common with God. That's the argument so far. But those who have reason in common must also have right reason in common, which is the ability to determine right from wrong. And since right reason is law, we must believe that men have law also in common with the gods. So those people who know right from wrong are those people whose ability to reason is closest to God's ability to reason, which we would have to assume would be perfect. And since right reason is law, we must believe that men have law also in common with the gods. Further, those who share law must also share justice, and those who share these are to be regarded as members of the same commonwealth. If indeed they obey the same authorities and powers, this is true in a far greater degree. But as a matter of fact, they do obey this celestial system, the divine mind, and the God of transcendent power. Hence, we must conceive of this whole universe as one commonwealth, of which both gods and men are members. So it's wordy, but it's fairly simply boiled down to we get our reason from God, and those people who know best the difference between right and wrong are those people whose reason is closest to God. Anybody see a problem yet with the reasoning here? Yeah.
There's more than one God, I guess.
Well, even within ancient Rome, there's more than one God, so that could potentially be a problem right there. Let's assume for the moment that he is appealing to Jupiter, the king of the gods. Does that clear that problem up?
Like, I guess when more than one God, like more than
Right.
And I feel like this is still happening in Rome.
Yeah.
More than one religion was also represented there, so I feel like there would have been a lot of conflict.
Well, sure, right? So, although within the Roman Republic there is in fact just this pantheon of gods, it isn't as if the Romans had not come into contact with other people who had different religious beliefs. It is possible, although I'm not 100% sure whether they had already encountered Judaism, which ultimately they will conquer Palestine, so they're going to have extended, protracted contact, not to say major conflict, with the Jews that live there. But they've also come into contact with the religious beliefs and communities that are to the east of the Holy Land. So particularly in Iran and in what's currently the Middle East. And this is before Islam, so these people are neither Christian nor Jewish nor Muslim. They have beliefs that are either the closest thing that I could liken it to would be a religion that is currently practiced only in India, but which was very broadly practiced in ancient Persia, Iran, called Zoroastrianism. Anybody know Zoroastrianism? I mentioned it before just as a point of distinction between the idea of good and evil in Platonic philosophy versus the idea of good and evil that was around mostly before, which actually is the idea of good and evil in Zoroastrianism. So a short diversion, but an important one. So Zoroastrianism was the major religion in Iran before the Muslims arrived. There's still a tiny community of Zoroastrians there today. They are protected under the law there, but a much larger community of Zoroastrians lives in India. And although it still is small compared to the Hindu and Muslim communities in India, there nevertheless is a significant in millions. And when you've got a country of 1.2 billion people, 1% is still a lot of people. The husband of Indira Gandhi, the former Prime Minister of India, he was Zoroastrian. So they believe in equal powers of good and evil that are embodied in two deities. There's a lot more to the religion, but to sort of bottom line it, that's the thing. So for them, they could perceivably say, okay, well, we would seek justice, therefore, in a person with, quote, right reason, right, the ability to determine right from wrong. We would say, the Zoroastrians would say, if they were applying the principle that comes out of Cicero, well, insofar as that person in our society who knows best is right from wrong, we're going to say that that person is closest in their mind or soul or reason to our good deity. Now, that's not a problem if Zeus and the deity in Zoroastrianism, his name is Ahura Mazda. So it's not a problem if Zeus and Ahura Mazda are identical or very, very close in their beliefs. But they're not. In fact, you don't even need to go to a religion that most of you have never heard of. You can just say, okay, well, what's the difference between Zeus or Jupiter in the Roman formulation and Jehovah, the Judeo-Christian Muslim god? Well, for one thing, Zeus, Jupiter, the main Roman god, he is rather fond of adultery. Commits it often, and often in animal form, which is how you get things like the Minotaur, right? Half bull, half man. So, yeah, Zeus is big on adultery. Jehovah, not so much, right? He puts it in the top 10 things of, that you're not supposed to do. So, now, I was talking a few minutes ago about how, we can identify from the 10 Commandments, from the big do-nots, the 5 big do-nots in the 10 Commandments, that 2.5 of them are in our legal code and 2.5 of them are not. Well, so which is in accord with this natural law that Cicero is talking about. And how do we know? Well, to some extent, that's going to depend on what God we're talking about and what moral code that God says is right and wrong. And it doesn't even have to be as sort of gray an area of law like adultery, because obviously there are still some societies that punish adultery. Adultery was illegal in all 50 states 100 years ago, although it isn't now. But capital punishment. I mean, Christianity bans capital punishment. Islam does not. So you can even go to the same God, and it really just depends on what text you're going to get that particular opinion from God. And that says nothing, by the way, about the legitimacy of the text itself, right? I mean, we know, for instance, that because the Bible has been studied intensively by people for more than 100 years in terms of understanding who wrote it and when, we can say with pretty much assurance that at least 4 different people wrote the first 5 books of the Bible, which constitute the Jewish law. And Jesus, who of course is a central figure in Christianity, it's not even claimed that he wrote any of the New Testament. And Prophet Muhammad, he was illiterate, so we know he didn't write the Quran. So there's a fundamental issue with the texts themselves. This is why this is, on the one hand, an interesting viewpoint about law, but on the other hand, a deeply problematic point about law. Because when you tie it too close to religious belief, it points out the inherent flaws in it, but it doesn't get rid of it entirely, right? I mean, because there is still this matter of whether law should reflect morality or whether law should just reflect the prevention of harm. And to consider this point a little bit further, think about the kind of government that Locke talks about in the Second Treatise of Government. He says, first of all, that there's minimal role for government just to protect you, protect the borders, protect you, settle property disputes. He says, second of all, that the greatest political power that we endow to government is the making of law, and that because this power is so great, the kinds of laws that are made have to be within certain traditions and commonalities that we all understand, as well as not infringing on any rights that we have. And that further, unless it ties back to one of these fundamental things that government is supposed to do, protect you, protect the border, protect your property, then it really shouldn't be made a law at all. Now think about drug laws. Where do they fit in that? Yeah. Right, so the argument is made that laws against drugs, particularly laws against selling drugs and trafficking drugs, are laws that are designed to protect you, right? But that makes certain assumptions. First of all, it makes the assumption that you can't decide for yourself what's good for you and what's not. And second of all, it also makes the distinction that and this is to say nothing of the possible, actual medicinal benefits that might be gotten, right? But it says also that if you limit the damage to yourself and not to anybody else, if what you do doesn't harm anybody else, that the law can be applied in some circumstances to a person selling drugs, but not to a person using drugs. We accept, for instance, that a person can overeat, which is unhealthy, or not eat enough, which is unhealthy, or for that matter, engage in any number of unhealthy activities that are perfectly legal and much more dangerous than a lot of illegal drugs, like smoking cigarettes and drinking alcohol, both of which are significantly more dangerous than most illegal drugs. So the question is, why do we have prohibition on drugs? And the answer is, to some degree, what Lauren said, but also to some degree that there's a moral judgment there. It would be quite difficult, and in fact was quite difficult when we did ban the use of alcohol in this country for 14 years to prevent people from doing it. There are a lot of reasons for that, not the least of which is that, well, it's addictive, so again, it has that whole problem of an inelastic demand curve, as well as that by that point, 1919, we'd already admitted a significant number of Catholic people into the country for whom ritual drinking wine was a weekly endeavor, part of the religious ritual. And then third of all, that it also sort of flew in the face of this general idea that you don't pass laws that go against common practices. And if people have been drinking alcohol for years and years and years, then Locke would say certainly that it makes no sense to pass a law against drinking alcohol, or for that matter to pass a law against smoking tobacco, because it's what we do. Now, it does make a lot of sense, as make this a final point, it does make a lot of sense to prevent people from smoking around other people when there's no recourse to fresh air, right? Because that's an actual injury that's being inflicted on somebody else. It's one of the reasons why you can't smoke in bars anymore, because if the bartender or waiter or whoever doesn't want to breathe your cigarette smoke, they don't have a choice about it. Whereas if you ban smoking in confined places, then the choice can be made. This is not to say, by the way, that these are particularly good or bad ways of doing things so much as different ways of doing things. So, but it goes back to this issue of tying what is just to what is moral. Because religions, by and large, are sources of what is moral, and can certainly be sources of what is just. And those two things are often very closely tied together. Ideally, we would say of a religion that a religion isn't very good if it doesn't provide justice in what it says is moral. But we also have to apply our common sense and say, well, okay, but I'm certain that for any of you that are that adhere to a religious faith, there's probably things within your own religion that you do not adhere to. I was just a final point. I was raised Catholic, and so, but neither of my parents come from a large family. My father's one of two, my mother's one of three. And I remember asking my grandfather once, because I was young and stupid, I asked him if how it was that they managed to only have 3 kids. And he said, "What are you, an idiot? We use birth control." Because you're not allowed to use birth control in the Catholic Church. That's a point I probably should have made before I told you the story. And then I went to my parents and asked about this, and they said, yeah, when we were growing up, nobody that was of a fertile age would take communion because everybody was using birth control. And everybody knew the church was against birth control. They just chose not to adhere to that particular rule. Now, on the one hand, that's fine within a religion, right? I mean, first of all, your relationship to your own faith and to your own God is something that you negotiate yourself, and everybody reaches their own particular line where they can draw it. Where it becomes more difficult is when those laws are when those beliefs then become law. And in particular, when those beliefs become law in places where not everybody is of the same religious belief, right? And so they just legalized abortion in Ireland. It had been legal, and then it was made illegal, and then it was made legal again. And there's a whole debate to be had about that, which is different from the one about birth control. But with birth control, it was illegal there for years. And that was fine by a majority of the people that lived in the country, because a majority of the people that lived in the country are Catholic, and for that matter were particularly devout in their Catholicism. But at the same time, it didn't leave it out for those people that weren't. And that was arguably rather something of a problem, particularly for a country that defined itself with its founding in the 1920s as a secular republic. Right? So that was a long diversion, but back to the text at hand. So page 535. Actually, let's go to 536. Law is the mind of God. Having dug himself this hole, he will dig slightly deeper. So, Cicero, again, our friend Marcus, says, well, then I find that it has been the opinion of the wisest men that law is not a product of human thought, nor is it any enactment of peoples, but something eternal which rules the whole universe by its wisdom and command and prohibition. What you have to do and what you can't do. Thus, they have been accustomed to say that law is the primal and ultimate mind of God, whose reason directs all things either by compulsion or restraint. Wherefore that law which the gods have given to the human race has been justly praised, for it is the reason and mind of a wise lawgiver applied to command and prohibition. So, this is sort of the clearest statement of what he's hinted at already for several pages, which is to say, how do we best identify what is the best form of law, the most just form of law? The best approximation in our civil law of what this universal natural law is. He says, well, that would be the mind of God, which then, of course, raises the question, well, how do we know that? And he goes back to our common answers, which is to seek it in a religious text, and I hope that I've sufficiently demonstrated the problems inherent in that. Never mind, by the way, the whole problem of seeking it from an oracle, right, from a priestess or a priest in a temple, because we know two things about them, or three things. One of three things about them. They were either lying, well, one of four. They were either telling the truth and they could actually talk to the ancient Greek and Roman gods. And remember, everybody is an atheist except for the god they believe in, right? So you're all atheists with regard to Jupiter and Saturn and those gods. But apparently, if you believe that these people were genuine prophets, then you have to at least afford the possibility that Jupiter and Saturn and Venus were real. That's possibility number one. Possibility number two, they were lying. Or the much more reasonable possibilities, which have been borne out by anthropology, they were you're crazy and hallucinating, or they were on drugs and hallucinating. So those things being the case, probably an even worse source of the mind of God to go to an oracle. His solution, of course, then is to seek the most just and reasonable people within a society. How good of a solution is that to the problem, by the way? Like, on one level, it begs the question, which is to say that it seeks to justify its argument on the basis of the argument itself. If you're saying that a person who knows best right from wrong is the person who best reflects what is universally right and wrong, you're nevertheless relying on some preconceived notion about what's right and wrong. There's no way of testing it. You can test it against the book you have, but we've already covered what the problem is there. You can test it against the oracle problem there as well. Is there any way out of that, though? So here's how the argument would go in defense of a position like this. So we just put somebody on the Supreme Court like a month ago, right? Brett Kavanaugh. And the question is, why was Brett Kavanaugh considered to be qualified to be put on the Supreme Court in the first place? And the answer is, well, he went to the Yale Law School. And then he served as a district judge. And of the people that are on the Supreme Court along with him, 8 other people, all of them have been district judges. And all of them went to Harvard, Yale, or Stanford law schools. I think one of them might have gone to Chicago. So they all went to top-level law schools, and they all served as district judges. So that is part of the way of answering this question. We look to those people who have succeeded best within our society in clearing certain hurdles. In, for instance, clearing first this educational hurdle. And then subsequently, after clearing this educational hurdle, clearing this professional hurdle. It happened a very long time ago, so I doubt if, and I know none of you remember it. It's possible some of you might have heard of it. But does anybody know who Harriet Myers is? Harriet Miers was the personal lawyer of George W. Bush when he was president of the United States. And when he had an opportunity to fill a Supreme Court justice, he nominated her. Here was the problem with that. She was not a district court judge before he nominated her. And so the hue and cry went up immediately that she was unqualified. And she was desperately unqualified. You can make an argument for the schooling thing, but you really sort of can't make an argument about the district judge thing. You really probably should be a district judge before you sit on the highest court in the country. And so her nomination was withdrawn. And that was sort of like this example of a check against a possible abuse of the system, as well as a sort of a reconfirmation of how we determine who has this highest faculty of reason, right? Because after all, if we are a secular society and we don't apply religious tests as our Constitution says we cannot, then we have to set some standard by which we can determine who will be the highest interpreters of our law. And in doing that, because we can't appeal to a religious test, and arguably I would say most people would say nor should we, then we have to set some other kind of standard. Passing through a top-level law school is one way of doing that, and fulfilling this occupational requirement of having served as a district judge is another. But it nevertheless yields a problem, which is that you've got 9 people on the Supreme Court of the United States. All of them have gone to Ivy League or equivalent law schools. All of them have been district court judges, but their beliefs in how to interpret the law are different, which means that you can set some standard that is supposed to determine how reasonable a person is, but this will not yield the same outcome. So my question to you is it that the test that we have set up fails, or is it that there's no right answer to the question that Cicero is trying to answer? Yeah.
Aren't there people that also kind of break that system and
What do you mean?
Aren't there people that will overcome those hurdles and will still get past?
There used to be. So, you mean to overcome the, well, so one of the few people that was a Supreme Court justice who, I don't know where he went to college. It's unlikely that he didn't go to Harvard, I'll say that. But he had not been a district judge. But he was Chief Justice of the Supreme Court, is William Howard Taft, who was more famous for being President of the United States. So, by the way, it would not surprise me if the next Democratic President of the United States names Barack Obama to the Supreme Court, because he's a constitutional lawyer with a Harvard law degree, and they've already put a president on the Supreme Court. So exceptions could be made again, right? That's if Barack Obama wants the job, which if he wants to be wealthy, he won't. Because he's already making money by making speeches for $250,000 a pop, and he's not going to make that kind of money as a Supreme Court justice, nor did he make it as president. So, but I digress. So yeah, there are ways to clear those hurdles, but the Harriet Miers example tells us that it doesn't happen very often. I mean, Taft was put on the Supreme Court in the 1910s, I think. So, no, it would have been in the 20s, because it would have been a Republican president to put him on there. So it would have been in the 1920s that Taft was put on the Supreme Court. The standard that we've at least set up now is the educational and occupational thing. With the occupational thing in certain extraordinary cases like President Taft being waivable, but the educational thing, not really. Which, by the way, just has its own inherent problems, right? I mean, although it is true that there are racial minorities on the court, right? There's one Latino woman, there's one black man. It is nevertheless the case that it is overwhelmingly the province of white men, less so now than it was 25, 30 years ago, but certainly white people, because of the correlation between race and socioeconomic status in our country, that these schools are much more commonly attended by white people than black people or Latino people. And there are no Asians on the court. So, What does that say about our ability to find, in fact, those people who are the best qualified? By setting this a limit or setting a hurdle before those people who can compete, which inherently disqualifies a large number of people. This is to say nothing of the literally tens of millions of white people who don't qualify for these schools because they can't afford them. So there are not currently any people on the Supreme Court from Appalachia, which is an overwhelmingly white place in our country, but that is nevertheless the poorest place in our country. So, what does that tell us about how well these places are providing truly the best people, or people that have been shunted toward elite status by virtue of the station into which they were born, which we can say for sure is the case with probably 6 to 7 of the 9 people that sit there today. With the other 2, Justice Thomas, who's black, Justice Sotomayor, who's Latino, they went to Harvard. They both went to Harvard Law School, and they both went on scholarships because they both came from very humble backgrounds. Justice Thomas came from what is arguably a place in the country that is at least as poor of Appalachia, if not poorer, and in fact didn't even grow up speaking English, which would be remarkable were it not for the fact, because Justice Sotomayor grew up bilingual. She grew up speaking Spanish and English. Justice Thomas didn't grow up speaking English at all. He grew up in a society that was so segregated that they were still speaking a Creole language where he grew up. And so it's a testament to his ability that he was able to rise up out of that, go to Harvard Law School, so on and so forth. Not to mention the scholarship money that he got to be able to do that. But, he's the only person from that community that's ever reached national prominence. The only one, the single one. So the question again is, well, to what extent are the hurdles that are set up in order to test this theory of identifying the person who has the best and the most honed sense of reason of right and wrong? To what extent are we able to determine these things by setting up certain qualifications, whether educational or occupational? If the answer could be found by people having this same opinion, the answer is that they don't work very well at all, because we've got a range of beliefs from liberal to conservative on the court. And again, the question therefore is it a failure of the test, or is it a failure of the idea? Is there such a thing as objective right and wrong? Because if there isn't, then the whole idea fails. And that's only a problem, as far as I can see, to a particular extent where there is a significant minority who begs to differ with the interpretation of right and wrong on an issue that is substantive enough that it will cause a real sense of injustice for that minority not to be properly heard. And so, as we go sort of through the rest of the term and talk about writers and thinkers who are influenced by these ideas, in particular influenced by this idea called natural law, which is what Cicero is sort of the major progenitor of. The writer that we'll look at whose ideas come the closest is Martin Luther King Jr., who appeals directly to these very same ideas, to the idea that a law that is truly just is a law that is in accord with the law of God. Now, on one level, he was a Baptist minister. We would expect him to make an argument like that. But at the same time, he was instrumental in a civil rights struggle that went well beyond that. And so the question is, well, what was the minority that was being that held a different point of view with regard to this? And the sort of the counterintuitive response to that is the segregationists were the ones that were the minority. Because for him to make a successful argument, and I think you have to concede that it was successful, that a law that would allow segregation is a law that is unjust because it is not in accord with the law of God, which is essentially his argument in a nutshell. You had a very significant and vocal minority nationally, although a majority certainly in some places in the South, that believed differently, and believed in fact so differently that they could justify their points of view in the very same book from which Dr. King justified his own. Which isn't to say, by the way, that therefore Dr. King was wrong, or that his way of arguing was illogical or flawed or faulty. Just that what he couldn't do, and so we'll get to that when we talk about King and civil disobedience and the arguments that he uses, that it is far less tied to the idea of natural law and morality than it is to a broader sort of sense of equal protection, which we'll talk about next time when we talk about the Constitution. So, I'm going to stop there and talk about your quizzes. So, the class average before curve was a 65, which is about average for the quizzes that I give, by the way. So I typically curve about 10 points, which is what I curved here. So it was a straight 10-point curve, by the way, so everybody got 10 points added to their grade. The number on the front, the larger number on the front of your quiz, is your straight number out of 150, which should then be divided by 150, multiplied by 100 to yield a number between 0 and 100, and then 10 points added for your curved grade, which is the one that's been entered on Blackboard. So, a couple of observations. First of all, people who did the essays did better than people who did the short answers. If you did poorly and you did 2 short answer sections, maybe try the essays next time. Second thing, and I mentioned this before, but if you don't know the answer, don't tell me everything you know about the people or the idea mentioned in the question, because it's after reading like my way through 22 of your exams, it gets a little blurry. So, and plus you can leave early if you don't know the answer. Just get up and go. So. Oh, and don't forget, by the way, third point, that you can drop your lowest grade. So there's that thing to think about as well. So there was the vast majority of the grades were between C+ and a B+. I think there were 3 failing grades and 2 A's. So it was a pretty normal curve after I curved it. So very briefly, define power. Well, power is control over resources. If you didn't talk about control and you didn't talk about resources, you lost points. Most people got this pretty much close. Second, what happens to the price of a good or service when its supply increases? The price goes down. Number 3, why does a plutocracy ultimately become a democracy? So there were a lot of sort of parts you needed to have in this, and you needed to have all of them to get all the points. And the idea here is that